Senator Bragg.
Thank you very much, Deputy President. Well, I rise to set out some facts in relation to a very curious case indeed in relation to Dixon Advisory and the non-enforcement of the law and the potential for taxpayers to be funding a huge moral hazard in relation to this particular business, but also into the future, given the existence of the compensation scheme of last resort. Now, in relation to Dixon Advisory, they saw $357 million of losses of money from consumers who had decided to invest into their fund through their advisors. There are now 2,000 AFCA cases before the tribunal in relation to the Dixon matter. Now, in 2020, ASIC started to take some action in relation to Dixon, and by the beginning of 2022, Dixon was in voluntary administration. Now, the core of the issue here is the allegation that there was deeply conflicted advice given to retail customers who were invested into New York property funds, and that the promoters of the scheme collected huge commissions and were able to get away with this, but inflicted huge losses on consumers because of the conflicted advice, whereby the promoters of the scheme, Dixon Advisory, put their own interests ahead of those of their investors, which is against the laws of Australia. Now, ASIC releases a statement in September 2020 setting out that it proposes to take action against Dixon Advisory in relation to conflicts of interest, in relation to contravention of the best interest duty, and also the requirement for Dixon to have given appropriate advice. But they only pursued some of those matters in the courts. And then later in 2021, there was a shock to many people who were watching this that ASIC decided to settle. They decided to settle for $7.2 million. That's it. That was the end of civil proceedings for $7 million after there had been losses of over $300 million and no pursuit of criminal matters. No pursuit of criminal matters. Now, we shouldn't be surprised here because we're talking about ASIC, an agency which has made fewer referrals to the Commonwealth Director of Public Prosecutions in relation to criminal matters than the Great Barrier Marine Authority. And over the last 5 years, ASIC has made half as many referrals to the Commonwealth Director of Public Prosecutions than they made 5 years ago, despite a huge increase in resources. So the maximum penalties here, in terms of just dollars on the civil basis, could have been well in excess of $100 million. But ASIC decided to pursue and settle for just $7 million. Now, the fly in the ointment here is that in October this year, I asked the ASIC Deputy Chair about this matter, and I said, ASIC agreed to a $7.2 million fine with Dixon Advisory. Did they pay that fine? And ASIC's Deputy Chair said, no. As I understand it, that fine was not paid. Dixon is in voluntary administration. There was a penalty imposed by the Federal Court of $7.2 million, but given Dixon is in voluntary administration, those amounts are unlikely to be paid. Let me repeat that, Deputy President. Those amounts are unlikely to be paid. Unlikely to be paid. So there's no criminal prosecution. There's no civil process other than a small fine, which is now not going to be paid. But the further fly in the ointment here is that Dixon Advisory has now phoenixed itself into Evans and Partners, which, according to their recent financial reports, has this year, from June 2023, has 5,500 clients that they're advising, sorry, 3,500 clients that they're advising, up from 3,000 last year, and they are increasing their revenue. In the last year, their revenue was $167 million. $167 million in revenue at Evans and Partners. So it doesn't sound like the Evans and Partners business and the Dixon Advisory business is short of cash, but apparently they can't even pay their regulatory fine of $7 million, which is only a fraction of what should have been sought through civil penalties if ASIC had been doing its job. Now, the thing I'm really concerned about here, though, is what has happened behind the scenes. There was a statement from ASIC on the 3rd of August 2022 which said former clients of Dixon Advisory and Superannuation Services in administration may be eligible for compensation under a potential future compensation scheme of last resort, but will need to take action as soon as possible. So that's what ASIC said in August last year. And then AFCA puts out a similar statement saying, after the legislation had passed, now that legislation has passed to establish a compensation scheme of last resort, we have commenced early work to investigate these claims and assess if they may be eligible to raise a CSLR claim. To ensure our caseworkers can efficiently deal with your complaint, you can start gathering relevant information in preparation for a contact. This is solely about Dixon Advisory. So AFCA have put out a release just about Dixon Advisory. And then we get to the budget in May this year, May 9, 2023. And Budget Paper 1 says, quote, "The value of the Australian government's liabilities under the CSLR is unquantifiable. The collapse of Dixon Advisory and Superannuation Services Pty Ltd may increase the liabilities for the Australian government." Now, I can't remember many times when the budget papers have specifically set out one particular organisation that would be part of a new scheme. Now, I should say at this juncture that the idea of the compensation scheme of last resort is a very risky concept because it does introduce the concept of moral hazard, whereby the regulators in particular may not be incentivised to enforce the law to protect consumers because they know there's a great big bucket of taxpayer funds sitting behind them that can come and bail them out if they fail to enforce the law. Now, when you have the worst corporate law enforcement agency in the OECD and the G20 on the case, you're going to need a lot of CSLR remediation, I would predict. But the curious piece here is, why did ASIC and AFCA and the Treasurer, Jim Chalmers, put out these statements about Dixon Advisory into their budget papers? It seems very curious indeed, where you have a situation where there have been huge losses. Over $300 million of people's money has been lost because of conflicted, bad, illegal advice. There is no law enforcement. No law enforcement. No law enforcement here. Nothing on conflicted advice, nothing on appropriate advice, and nothing on conflict of interest. No fine collected. The piddling fine that ASIC agreed with Dixon of $7 million. $7 million after a loss of $300 million is not even going to be collected. Not even going to be collected. And we shouldn't be surprised, because the ASIC inquiry has revealed that the anti-phoenixing laws are not enforced in Australia. And what we see here is effectively the phoenixing of Dixon Advisory into Evans and Partners, where we see a profitable ongoing business, which somehow can't find any ability to pay its fine. And therefore, who's left with the bucket here? Who's left with the bucket? It's the taxpayer. The taxpayer will now have to fork out and provide reparations to people who have lost their money and were not able to be compensated because ASIC didn't do its job. But why has Dixon been singled out here? This is the question. Of all the dreadful financial scandals going back to Storm Financial 10 years ago, 12 years ago perhaps, no one's ever been bailed out. And there have been so many consumers wronged by an industry which has too often put itself ahead of its clients' interests, but also a weak, pathetic regulator that has not enforced the law. So the question is, why has Dixon been singled out here? We need to know why, and I will be pursuing this.